Hi, my name is Scott Green. I'm the managing partner for the Green Law Group in Simi Valley, California. And today's webinar is part of our continuing series, which we call the Master Contractor Webinar Series. And the topic for today is employment law factors. So before we jump into it, let me tell you a little bit about who I am. We'll introduce our sponsors, a little bit about my law firm, and then we'll jump into the seminar material. So first, a little bit about me. I have been practicing law, construction law primarily since 1978. I worked my way through law school as a contractor. My dad was a contractor, so I kind of learned it from him, all the way from, grammar school, basically helping to clean up through high school, and then it helped me put myself through law school. So I've got construction chops running through my veins, and I primarily do this because I understand the construction industry, and I want to help contractors succeed. So the Green Law Group is basically built for contractors. So in today's seminar, we've got a few sponsors that I want to thank. And these sponsors are here because I think they're also potentially valuable for our seminar webinar participants. So to start with, we have Easy Law Construction Notices. Easy Law is a company that I formed actually in 1985 to help contractors secure and collect what they make. So how does Easy Law do that? They do that by sending out preliminary notices, preparing mechanics liens, stop payment notices and bond claims on behalf of their clients. And it's an incredibly important service. Easy Law has thousands of clients in Southern California and throughout the country, and they do an absolutely fantastic job. So if you haven't become aware of them yet, please check them out. They're on the web at easylawinc.com. And we also have the Blue Book as a co-sponsor. The Blue Book's been around for 100+ years. And it's a great networking organization for contractors. Check them out. And we have the Builder's Book. The Builder's Book, their physical store is in the Canoga Park in San Fernando Valley in Southern California, but they have a website which is just phenomenal. And basically, if there's something in text, they text regarding construction, they probably have it. Then we have the Ventura County Contractors Association. There are contractor associations, all over the country. You should check out your regional area for an association, and great place to network, exchange ideas, be updated with changes in your industry. So I recommend contractor associations to everybody. And then I have a lender. Ventura County Credit Union in this case. VCCU is a co-sponsor because I have personally found that they're flexible. They take into account somebody's character, reputation. Of course, your assets and credit profile are very important as well. But where as a small regional community bank, they can do things that some of the larger banks cannot do. So in your area, if you haven't investigated credit unions, check them out. Okay, so let's go to the next slide. And this is just something that I think is a truism. Knowledge is power. So congrats to everybody who's listening in today. And you're going to be more powerful as a result. Next slide. So here's my disclaimer that what you're going to hear today is basically general information, and it isn't specific as to your particular situation. So for your specific questions, you want to talk to a lawyer and not just simply rely upon the general info that I'm going to pass out today. Next slide, please. Here's a little bit of information about the Green Law Group and our philosophy. You can read this later at your leisure. Next slide. A little more about the firm. Next slide. This is me. That's my handsome picture that's probably, I don't know, 5, 6 years old. I'm not changing it because I have more hair there. So it's going to stay up for a while. And here in part of my bio, it says, that, yeah, in 85, I founded the Green Law Group. Next slide, please. It's my partner, Stephen Sanders, and Stephen is uniquely positioned to help contractors as he is also a licensed general contractor and a licensed real estate broker. So he knows this industry inside and out, and is just a fantastic lawyer. So next slide, please. Jeff Conier in our office is our insurance coverage expert. This makes a heck of a difference if you get sued and you can get insurance coverage to come in and pay for the defense. That's one of Jeff's specialties. He's also an outstanding litigator. Next slide, please. Mike Calipore is, I obviously like all of our attorneys, and by the way, I don't hire somebody that I wouldn't retain myself personally to represent me. Mike does a lot of our business work, our estate planning work, and he's also a tax lawyer. Next slide, please. Matt Bachdell is our head of our employment group. And so if you follow up with us on an employment issue, you're probably going to end up talking to Matt. He's just outstanding. Next slide, please. Nick Cade, one of our associates, is he supports basically all of our practice areas, working with the other attorneys and directly with clients, and he's also phenomenal. Next slide, please. We're missing a slide. We have another attorney in the office. His name is Kurt Robbie, and we'll get Kurt's picture up there, and I think you can see him on our website. So let's jump into the topic for today, employment law. And that started with this issue of, is somebody an employee or an independent contractor? That might seem like an easy question, but it ends up not being so in practicality. I have a lot of folks that contact me and say, oh yeah, I've got these laborers or people who do work for me on occasion, and I pay them as independent contractors, and I give them a 1099. Well, in California, there is a presumption in the law that if a licensed contractor hires someone to perform construction work, and that person doesn't have their own contractor's license, that they're not an independent contractor, they're an employee of the party that hired them. So, let that sink in. Now I'm not talking about your office staff. I'm talking about people you hire to go out in the field and, perform construction work. So if you've got somebody that you use on occasion and you didn't want to put them on your payroll, but they're not a licensed contractor, they're your employee. And that has a lot of ramifications. So that's something you need to clean up. And if you're doing that, you need to chat with an employment attorney and get that situation figured out, because that can come back and really be devastating. Next slide, please. So here's another area that contractors need to educate themselves about is when can an employee be exempt from the overtime requirements? Now that's a big deal, because if a lot of people think, well, gee, I'm paying somebody on salary, so they don't need to check in and out, they don't need to have a time card, I don't need to be concerned myself with whether they get rest breaks or they take a lunch. Well, whether somebody is paid via salary or hourly is not what determines whether they're exempt or not. There are very specific rules that make people exempt. And the kind of the general default is somebody is not exempt, meaning that you have to pay them minimum wage. You have to make sure that their time cards are correctly done, that they're getting a break in the morning and in the afternoon, and that they have an uninterrupted lunch break. And if they go over 8 hours in a day or 40 hours in a week, that you're paying them overtime. So that should be your baseline. If you think that somebody qualifies for exempt status, you want to have that confirmed by an attorney. Because if you get that wrong, then you could be facing significant liabilities. Let's say that you have a project coordinator who bids jobs, maybe they even sign contracts, but they also fill in and put on the tools, and they work at projects where necessary, and more than half of their time is spent actually doing construction work, but you're paying them exempt. And they start their day very early in the morning and maybe late into the evening scheduling things, and they might be putting in 10, 12 hours a day, and you're not compensating them for overtime. Well, there's one of the rules about whether somebody can be exempt or not is whether they spend more than half their time working on exempt duties. Exempt duties are things like, making a discretionary decision, signing contracts, hiring and firing people. That would qualify as exempt work. But if you've got somebody that's doing some of that, but more than 50% of the time, they're actually doing more discrete tasks like, working on projects, they're not exempt. And if they're, not clocking in and out, you're not tracking their time, you're not paying them overtime, etc. That can lead to significant liabilities. Next screen, please. So take your time and go through some of these bullet points here for determining whether or not somebody that you're paying as exempt from overtime actually might qualify. But again, I can't emphasize enough that this is a really important decision, and you don't want to make it on your own unless you are truly an expert in employment law. Next slide, please. So a little bit more of the same. And by the way, if you get this wrong and your misclassified employee files a lawsuit, something to keep in mind is that they're going to have an easy time finding a lawyer because the laws generally provide that employees who sue their employers, if they win, even just a little bit, they can recover their attorney's fees. Well, that can be hugely significant because it would not be unusual at all for a matter that goes all the way through trial or arbitration for the attorney's fees to be, and hold your hats, $250,000 to $500,000. So let's say you go all the way through that process and you think, yeah, I'm not caving. I'm going to fight this to the bitter end. I don't believe this nonsense. And at the end of the day, you get tagged with, $10,000 or $15,000 worth of damages. Well, then you're going to get hit with a tsunami of attorney's fees, which, could basically, put you out of business. So it's super important to know what you're doing here and get help. Next slide, please. So same issue on misclassifying somebody as an independent contractor. We're going to power through a lot of slides here, so get back when you have time and go over these bullet points. Next slide, please. More on this issue of exempt, non-exempt. Read this when you have a chance. Next slide, please. Okay, so here's a little more with some examples of, how you can make the determination as to whether somebody is exempt or not. Next slide, please. Okay, minimum wage for somebody who is classified as exempt, for instance, they've got to be paid at least double the minimum wage. For those people who are not exempt, they have to be paid at least the minimum wage for all time worked. And here's a chart on what those hourly requirements are in California. And they've been going up by law since 1979, since 2017. So make sure you know what those requirements are and that you strictly comply. Next slide, please. So in addition to what the state requires, there are localities that actually require you to pay more. So for instance, Los Angeles has separate rules and requirements, and as do many other places. So if you've got employees who are working, in other jurisdictions other than where your office is located, then you need to determine how much time they spend there and whether that requires you to pay them minimum wage in accordance with that local jurisdiction requirement. Real important. It's complicated, but it is what it is. So be aware and figure this out. Next slide, please. So here's just an example of, an administrative exemption, what somebody in that category would be doing. This is for your general info. Next slide. Here's a different type of exemption. Next slide. California Fair Pay Act, that requires that there is a fair and equitable pay to genders. So if you've got a male who's doing certain tasks, and then you've got a female who does roughly the same thing, but you're paying the male more, you're exposing yourself to liability. Next slide, please. Alternative work week schedules. Folks don't really understand what you have to do in order to properly put these alternative work week schedules together. It's a little complicated. You've got to, enroll your employees. You've got to give them notice about what it all means. Basically, then you have to have an election, and they'll have to sign off on it. So there's a checklist here of things that have to be done. You can't just decide, we're going to go to 410s and just announce it and, think that that's okay. It's not. Here's another area where you should check with a lawyer. Make sure you've done this correctly. Next slide, please. Okay, so when you're hiring people, this is not a casual decision. When you're hiring somebody, I'd like to recommend that you keep in mind that if things don't work out, you need to let them go, and you've, in the meantime, violated some, employment requirements, and you get sued. Remember that $250,000 to $500,000 attorney fee bill? Well, if you keep that in mind at the beginning, then when you're putting your applications out, you're interviewing people, you are going to, maybe be a little more careful about it, make sure that you're doing things correctly, and taking some steps to perhaps minimize your liability. One of those important steps is entering into or conditioning your employment offers on having your new employees agree to arbitrate any disputes with you, as opposed to filing a lawsuit, which could ultimately have you making your case to a jury of 12 folks and realizing that the jury is in all likelihood going to be made up of folks who have been employees and not employers, and so their sympathies might go to the employee And your fate, could be decided by these folks in an employment law dispute that goes to jury trial. So you have arbitration agreements, then, you're going to avoid jury. That's the big reason to do that. There are some financial, obligations that you're going to take on if you have arbitration agreements. And you want to do them ideally when you hire somebody to make it a condition of employment. You can also have your existing employees execute and agree to arbitration. And again, you should talk to a lawyer about this. Make sure you get it right. Next slide, please. Okay, so here's some drill down info. Kind of some do's and don'ts with applications and interviews. Next slide, please. More about that, interviewing tips. Point here is you can't just be casual about it, just wing it. So you've got to figure out what you're doing here, because there are pitfalls, and if you fall into any of these pitfalls, you could be staring down the barrel of a lawsuit. Next slide, please. Okay, some more general info. By the way, these PowerPoint slides are part of our a much larger PowerPoint that, if you don't have it already, follow up via email with me and I'll send you a copy of it. It's a good training manual for not just employment law, but all sorts of things having to do with construction and business law. Next slide, please. Okay, more of the interviewing tips. Next slide. Social media, there are some do's and don'ts there, things that you can't ask for, can't ask for. For instance, you can't ask for somebody's password and go, navigate through all their social media. Next slide, please. Okay, background checks. These are a good idea, but there's a procedure and there are restrictions on what you can and can't do, and having to get authorization before you do them. So again, before you jump into anything like this, check with a lawyer. Next slide, please. E-Verify. California has some very strict restrictions on the use of E-Verify. However, the federal government has a different view of it, and they encourage it. Excuse me. So you have to know when you can and when you can't use it, because if you get it wrong in California, it can be very expensive. There's a civil penalty of $10,000 per violation. Next slide, please. Okay, job offers should be in writing. And like I said, you can condition these offers on things like a background check or things like entering into an arbitration agreement. Next slide, please. And here's some drill down info on arbitration agreements. You can take a look at your leisure. Next slide, please. Okay, this is more kind of practical, but also legal. I mean, what are the things that you have to have for a new employee? You got your list here. Next slide, please. Okay, kind of a little bit more of the same things that you need to be aware of for your, not just new employees, but all your employees. Next slide, please. Okay, we've talked a little bit about minimum wage. I think this is pretty self-explanatory. Let's go to next. And same thing here. Let's go to next. Fair Pay Act, we talked a little bit about. This is a little more drill down on that. Let's go next. Now, here is that statute that I talked to you about earlier. Actually, no, this is a little different one. This is relatively new and makes general contractors liable for the wage and hour claims of their subcontractors with certain limitations. So if you're a GC and you think, yeah, I know how to work around this, I'll just hire a sub and I won't worry about whether or not the sub is paying their folks correctly or not. And if it turns out that they're not, and the sub's employees sue him, they can sue you too. So that's something to be aware of. Next slide, please. So here are some of the restrictions and where that applies, where it doesn't apply. So read this at your leisure. Next slide, please. More of the same. Next slide, please. More about this. Next slide, please. Okay, travel time rules. This is another potential pitfall. So basically, when if you tell your employees, hey, I want you to go to the shop at 6 o'clock and load up the truck and then drive from the shop to the job. And then if you're starting their pay when they get to the job, well, you've messed up, because when you ask them to go to the shop, and I'm talking about hourly employees, their time started when they got to the shop. So if you think, well, I've got 4 or 5 guys and they're all going to carpool, and I told them to go to the shop so they could do that, I'm just doing that as a courtesy to them. No, when you require them to go to the shop, they get there, they're on the clock. So you can be really careful about that. Let's say you have one guy who's driving the truck and he's going to be at the shop, and you let some other people know that they can catch a ride with him, but it's their option and for their convenience and is not required. That's different than telling them they all need to show up at the shop and go from there to the job site. If you tell them, hey, it's for your convenience, and they take you up on it, they're not on the clock until they get to that first job site. But let's say while they're at the shop, they help load the truck. They just say, hey, let's just help out, and they load the truck. Well, now they're working at the shop and they're on the clock. Next slide, please. So here's some drill down on this. Go through this at your leisure. Next slide. More drill down. Next slide. Okay, there's more, because there's a lot to it when you kind of, consider different circumstances for travel time. So I recommend that you have a written travel time policy and that you make that part of your handbook or as a separate handout, and you have people sign off on it that they've received it, and you actually pay attention to it and comply with it, and you have it reviewed by a lawyer. And then here's this last part here, which is significant. If you're not sure whether you got it right or not, unless you get that clarified with somebody who does know, go ahead and pay somebody, because delaying the payment to them or paying them wrongly can subject you to that scenario we talked about earlier, where you now got sued, and even if there's just a little bit of money involved, the attorney suing you might just want to take it all the way to trial, because it's money in the bank for them. They go all the way to trial, they win, they're going to get their attorney's fees. And those fees, by the way, are going to be fat. So meaning they're going to charge, more significant time for their hourly rates, and they're going to work the case like crazy. Because at the end of the day, if they've got a good violation from their perspective of law, they're going to win, and they're going to get all those fees back. Next slide, please. Okay, when an employee uses his or her own personal vehicle, well, you got to reimburse them for all their expenses. So there are a couple of different ways to do that. You can reimburse for actual expenses, or you can use the IRS rates. Recommend you use the IRS rates. Check with your accountant on those. Next slide, please. Okay, a PAGA claim. A PAGA claim is where you have one individual who files a claim against you on behalf of everybody who's working for you now and who has worked for you in the previous 4 years. And it's a kind of class action. And it is not subject to arbitration agreements. So PAGA claims are very scary for employers, because you can make an innocent mistake and then be subject to a PAGA claim and find out that, well, that error you made actually, maybe you have to pay $100 or potentially pay $100 every time you made that mistake. But now you multiply that by the number of employees that you have currently and did have over the previous 4 years, and it can add up. So another reason why, you need to make sure that your wage and hour practices are signed off on by somebody who knows what they're doing. Okay, next slide. A little more PAGA, next slide. Piecework, don't like it. In California, it's, used to be quite prominent. Now it's very restrictive. The problem with it in past years was people got paid by the piece, but that didn't necessarily mean they got paid for all their time on the job, or that they got their rest breaks, or they got their lunch breaks. So California came in and legislated in this area, made it much more difficult to actually use piecework. So my suggestion is don't use it unless you've had your policy signed off on by a lawyer. I know I sound like a broken record, but it's that important. Next slide, please. Okay, more on that. Next slide, please. Okay, on-call standby time. If you've got somebody and you don't have work for them right off the bat, but you tell them, hey, look, hang by the phone. I'm going to call you. I think I'm going to need you in an hour or so. Well, basically, you're controlling their time and you're going to have to compensate them. So read through this. Next slide, please. Paid sick leave. Now, this is something that's come up in the last few years. There are state requirements and local requirements, and there are a couple of different ways to calculate it. So LA has a minimum of 6 days. The state minimum requirement is 3 days. So this is something that, again, you need to have it reviewed and approved by either an HR professional or employment lawyer. Next slide, please. Okay, more on sick pay. Next slide, please. More. Next slide, please. More. Read all this stuff at your leisure. Okay, now for exempt people, like let's say that you have correctly classified somebody as exempt, but then they miss half a day and you want to deduct from their pay. Usually can't do that, so you want to understand what those rules are. Basically this seminar or webinar is issue spotting. So, I could spend a lot of time on some of these topics. I mean, could actually be full day seminars in themselves. We could talk about travel time for a couple hours. We could talk about exempt, non-exempt for a couple hours. So I'm just hitting the highlights here, and I'm moving through a lot of info because there is a lot of information that needs to be on your radar that you need to know about. So I'm hoping that, this will just give you the idea that, hey, you need to make sure that on your employment practices that somebody knowledgeable has gone over and audited your practices to make sure that you're staying in the right lane and that you do that on a regular basis because these laws change all the time. So I would say at least twice a year, have your practices audited so that you're ensuring that you're not running afoul. Next slide, please. Okay, here's some more information that may or may not apply to you. So take your time, read through this. Next slide, please. Okay, so this is one that gets missed a lot. Let's say you have your employees, you require them to use their own cell phones for work-related matters, but you never reimburse them. Well, that's a violation. You have to reimburse your employees when you have them use their own equipment. And so, for instance, remember PAGA? Let's say you've got, over the last 4 years, you've had 50 employees. You required them all to call in or to have cell phones so you could contact them via phone. and you never reimbursed anybody for the use of their cell phone, well, it might be a little money for each individual, but add it all up and it's a claim, and then throw in the lawyer's fees and it puts you out of business. Next slide, please. All right, well, prevailing wage requirements for public projects, that can be, a completely separate webinar topic as well for many hours or a day. So if you're working on public works projects, you basically need to be expert on this issue of prevailing wage requirements. Next slide, please. Okay, so we've come to the end. I try to keep these things close to or about 30 minutes because I know people are busy and attention spans, start to wander. So we've flown through a lot of info here. By no means, did I give you all of the information you need to kind of make decisions. Basically, what I have done or hoped to have done is just to make you aware of how tricky this area can be so that you're going to do some reading on your own and you're going to reach out and get some expert advice so you can keep yourself out of trouble. So until next time, take care, make some money out there, and be safe.